Hi, hello everyone. Welcome back to my channel. We are back with the glossary of legal terms. The first phrase today is jus commune. Jus commune is a Latin term meaning common law in the sense of general principles of law shared across jurisdictions. Historically, it referred to the blending of Roman law and a canon law in medieval Europe, forming a common legal framework. Today, it can denote general principles of international or European Union law that supplement national systems. Its scope lies in harmonizing diverse legal traditions under common doctrines. It demonstrates how shared legal heritage can provide unity while respecting local variations. The next phrase is per curiam. Per curiam means by the court and it refers to an unsigned court opinion issued collectively rather than by an individual judge. It signifies institutional rather than personal authorship. Per curiam decisions are often brief and deal with settled principles of or urgent matters. The scope includes constitutional rulings, appellate reviews, and summary dispositions. They reflect the court's collective voice without attribution. The next phrase is negotiable instrument. A negotiable instrument is a signed written document promising payment of money to the bearer or order transferable by endorsement or delivery. Examples include checks, promissory notes, and bills of exchange. The scope is governed by commercial statutes that define negotiability, liability, and defenses. Negotiable instruments facilitate trade by serving as substitutes for money. Holders in due causes enjoy special protections against prior claims and defenses. The next phrase is writ petition. A writ petition is an application to a higher court requesting extraordinary relief, for example, certiorari, mandamus, prohibition, or habeas corpus, where ordinary remedies are inadequate. It is used to challenge jurisdictional errors, illegal detention, grave procedural irregularities, or to compel public authorities to fulfill legal duties. Writ petitions often require showing urgency, lack of alternative effective remedy, and that the issue raises substantial legal questions. Relief granted by writs is discretionary, that is, the court decides whether to entertain the petition, and may lead to squashing lower orders, directing administrative action, or addressing fundamental rights. Procedural rules govern form, time limits, and grounds for writ petitions, and courts sometimes set high thresholds to preserve judicial resources. The next phrase is fraudulent conveyance. A fraudulent conveyance or fraudulent transfer is a transfer of property made with the intent to hinder, delay, or defraud creditors, or made for inadequate consideration when the debtor was insolvent or became insolvent as a result. Creditors, bankruptcy, trustees, or courts can unwind such transfers and recover assets for distribution to creditors. Laws typically distinguish actual intent fraud, that is subjective intent, from constructive fraud, that is objective tests such as insolvency and a lack of reasonable equivalent value. Remedies include avoidance of the transfer, restoration of the asset to the debtor's estate, and sometimes damages against the transferees. Safe harbor rules, bona fide purchaser protections, and a statute of limitations periods affect a scope and enforcement. The next phrase is jus despondendi. Jus despondendi is the right of an owner to dispose of or transfer property. It is a fundamental element of ownership along with the rights of use and enjoyment. Restrictions on jus despondendi may arise from law, for example, inalienability of certain lands, cultural property, or trusts. The scope includes sales, gifts, mortgages, or bills made by lawful owners. Courts often enforce it to protect market transactions and individual autonomy. The next term is naturalization. Naturalization is the legal process by which a foreigner acquires citizenship of a country. It typically requires residency, good character, and allegiance to the state. Naturalized citizens gain rights similar to native-born citizens. The process may involve language and civic tests. Naturalization strengthens integration into the host society. The next term is domestic relations. Domestic relations refers to legal matters involving family relationships. It includes marriage, divorce, child custody, maintenance, and adoption. Courts handling domestic relations aim to protect the welfare and family stability. Special procedures often apply to ensure confidentiality and fairness. Domestic relations law is central to regulating personal and societal order. The next phrase is writ review. Writ review refers to a higher court's reconsideration of its earlier writ decision or to the process by which a court reviews the merits or legality of administrative or lower court decisions via writ jurisdiction. In many systems, once a writ is desired, review or revision is available only under narrow circumstances. For example, new evidence, clerical error, or clear error of law, and not as a routine rehearing of facts. Procedural safeguards limit writ review to preserve finality and prevent repeated litigation. Some jurisdictions allow review by a large bench or on petition for special leave. Writ review can be a vehicle to refine legal principles, ensure consistent jurisprudence, and correct manifest injustice. Parties seeking writ review must typically meet stringent criteria and deadlines. The next phrase is jus gentium. Jus gentium, or law of nations, originated in Roman law to describe legal principles common to all peoples. It later evolved into the foundation of modern international law. Its scope included trade, contracts, and a diplomacy between foreigners and Roman citizens. In a contemporary law, jus gentium denotes principles recognized by civilized nations, often incorporated into treatises and a customary law. It represents the universal aspects of justice transcending local laws. The next term is negotiation. Negotiation is a process of communication and bargaining between parties to reach an agreement or resolve a dispute. It is a core skill in contract formation, diplomacy, labor relations, and conflict resolution. The scope includes distributive bargaining, that is win-loss, and integrative bargaining, that is win-win. Negotiation can be formal or informal, structured or unstructured. Successful negotiation requires preparation, strategy, and relationship management. The next phrase is integrated agreement. An integrated agreement is a written contract that is intended to be the final and a complete expression of the parties' agreement. It prevents the introduction of prior or contemporaneous oral or written terms that contradict the written contract under the parole evidence rule. The scope depends on whether the agreement is fully or partially integrated. Courts look at the wording, merger clauses, and negotiation history to decide integration. Integrated agreements provide certainty and reduce disputes over alleged side terms. The next phrase is illusory promise. An illusory promise is a purported promise that in fact imposes no real obligation on the promiser and therefore lacks the consideration necessary to form an enforceable contract. Examples include promises that are entirely discretionary, like the promise, "I will buy from you if I feel like it," or contingent on events wholly within the promiser's control without limits. Courts look beyond form to substance. If the promiser retains unfettered discretion, the promise is generally unenforceable. But added obligations, exclusive dealings, good faith, or minimum orders, and can render it binding. The doctrine prevents parties from creating sham contracts that appear to commit but leave performance optional. To avoid illusory promises, drafters include objective standards, definite performance criteria, or mutual obligations that create a real legal consideration. The next phrase is constructive dismissal. Constructive dismissal occurs when an employer's actions force an employee to resign. Examples include drastic pay cuts, harassment, or creating a hostile work environment. Although the employee resigns, the law treats it as wrongful termination. Employees can claim compensation or reinstatement under labor law. This protects workers from indirect, unfair employment practices. The next phrase is integration clause. An integration clause, also called a merger clause, is a contractual provision stating that the written agreement represents the complete and exclusive statement of the parties' terms. It is designed to exclude reliance on prior oral or written negotiations. Courts use it to apply the parole evidence rule and uphold contractual certainty. The scope includes protecting against claims of additional promises unless fraud, mistake, or duress is shown. However, integration clauses cannot bar statutory rights or obligations. The next phrase is freedom of expression. Freedom of expression is the constitutional or human right to hold, receive, and impart information, ideas, and opinions without undue government restrictions. Its scope varies by legal system. Most jurisdictions protect political speech strongly, allow reasonable time or place or manners restrictions, and limit expression when necessary for public safety. Defamation law, privacy, or hate speech rules. Protection can apply to spoken and written words, symbolic content, artistic works, and increasingly to online speech, subject to platform moderation and intermediary liability rules. Courts balance freedom of expression against competing rights and interests, often applying tests such as proportionality or stricter scrutiny to governmental restrictions. In a private contracting context, parties may waive or contractually limit expression, non-disparagement clause, but a statutory free speech protections constrain only state action, not purely private censorship. The next phrase is negotiator immunity. Negotiator immunity refers to the protection granted to mediators, arbitrators, or diplomats against the legal liability for actions carried out during negotiations. Its primary purpose is to ensure that parties can engage in candid and a good faith dialogue without the fear of lawsuit or personal consequences. This protection is often recognized in international law for diplomatic envoys and in domestic statutes for mediators in dispute resolution. However, negotiator immunity is not absolute, as acts of misconduct, fraud, or actions beyond the scope of negotiations may fall outside its coverage. By safeguarding negotiators from undue legal risk, the doctrine helps preserve the effectiveness, impartiality, and openness of the negotiation process. The next phrase is the Kenya Doctrine. The Kenya Doctrine is a judicial philosophy associated with Harilal J. Kenya, the first Chief Justice of India, and it played a crucial role in shaping the early interpretation of the Indian Constitution. It emphasized the judicial restraint, respect for legislative intent, and a balanced approach between protecting individual rights and preserving state authority. This doctrine guided early constitutional rulings, particularly in affirming judicial review and establishing the primacy of fundamental rights. Rather than adopting a rigid textualist approach, the doctrine encouraged interpretation within the broader democratic and social framework of India. Over time, the Kenya Doctrine influenced the subsequent courts and helped establish the foundation for India's evolving constitutional jurisprudence.